So I'm Debbie Schrager. I am the director of the Supreme Court Institute, and I'd like to welcome at least Georgetown law students here to this event, as well as hopefully many students who are also watching remotely. And also there are members of the wider Georgetown community who are watching as part of the university's recognition of the recent Constitution Day observance. So in addition to special events like this one, the Supreme Court Institute, I wish I could take my glasses off. I'll say this again. In addition to special events like this one, the Supreme Court Institute hosts moot courts for advocates arguing virtually every case that the court hears each term. With an advocate's consent, we can offer Georgetown law students the opportunity to observe a moot court, a unique experience that I hope you'll take full advantage of while you're enrolled at Georgetown Law. The Student Preview is an annual event that gives our students the opportunity to learn about some of the most important cases the court will hear in the upcoming term, which begins this year on Monday, October 3rd. I'd also like to say we couldn't host this event without the support of Ian Main, Deputy Director of Special Events, and the Law School AV team. I would also like to give special thanks to SEI Assistant Director Cal Goldie and to our fantastic student research assistants whose work makes it possible for Georgetown law students to attend our moot courts: Hasla Arialakna, Kira Cooney, Hannah Geringer, and Blake Phillips. And we are very grateful to the law professors who are participating in this year's program. You'll see information about their background in the handout we've provided. So I'll just introduce them now briefly. Professor Kelsey Corcoran is the Supreme Court Director at the Institute for Constitutional Advocacy and Protection Law. Professor Michael Gottesman is the Reynolds Family Endowed Service Professor and teaches criminal justice, evidence, and property. Professor Robin Lenhart is the Associate Dean for Diversity, Equity, and Inclusion and co-leader of the university's Racial Justice Institute. Professor Madhavi Sunder is the Frank Sherry Professor of Intellectual Property and Associate Dean for International and Graduate Programs at Georgetown Law, and she teaches copyright law. And our moderator for today's program is the Executive Director of the Supreme Court Institute, Professor Irv Bornstein. Professor Bornstein teaches constitutional law and co-teaches seminars along with federal judges focusing on Supreme Court case law. Thank you again to everyone for participating and for attending this event. And the reward for those of you who are with us in person is that we invite you to join some ice cream at the end of the Professor Bornstein.
Can everybody hear me in the back row? Excellent. So, last term was probably the most tumultuous term that there has been while I have been an observer of the Supreme Court. We are not going to see anything quite like that this term, but we may come close. There are some really high visibility, high profile cases of great importance that will be argued this term and decided this term, and we selected a few to present to you today. And just before we get started, we have a hard stop at 5. Is that right? We'll stop at 5. If you can't make it till then, please exit now, because it's very, very distracting to have students walking and parading out as others are trying to hear what our presenters are saying. So we'll present 4 cases, and then at the end, we'll have some time for student questions. So
I was just going to mention that we do have an overflow room right next door. So if for some reason you feel like planning on getting out of here early, you can just quickly go ahead next door and watch the program. So I mentioned that was going to have someone.
Okay, and as Debbie said, we have ice cream at the end, so it's worthwhile. Wait it out. We're going to start out. Robin is going to present the affirmative action cases.
So it's great to see all of you, to see students who I missed over the summer months. And it's great to be in conversation with one another about issues that are so important to all of us as students, as lawyers, as court watchers. I am going to be a little unorthodox in the sense that I'm going to give you some quick and dirty information about some of the cases, but I'm finding it hard these days to talk about some of these issues that are surfacing, and I want to address some of them shortly, while I also give you a sense of sort of where we've been in action. But before I do that, I want to do two things. One is, I can't remember now who said that the 3rd of the month is the first day of the court's sitting. And I mention that because my birthday is the 3rd and so I'm thinking that maybe that's going to help a little bit and get things rolling in the right direction. Speaking about right directions, I want to say a little bit about directions for me that are not aligned with what I thought about when it comes to the role of the court, especially the court currently, and the efforts that justices and students and lawyers are all focusing on in this moment. It feels that we're all sort of, to me, it feels that we're all sort of jumbled up a little bit and wondering how to move forward. The Dobbs case for me was a very difficult and hard case to read, mostly because it strays so far from what I think of when I think of the justices who sit on the Supreme Court. I had the pleasure of clerking for Justice Breyer, and I learned so much from him, and much of what I learned from him was how to lose. He lost a lot, but he had a clear understanding about his beloved court and the role that the justices who sit on that court must carry out. And so I offer Dobbs because for me, that was a real turning point. We have a loss and also confusion, I think, across the line, right, wherever you stand in terms of your individual politics. Lots of questions about what do we do, right? How do we think about this when we have such a big shift from where we have been? And so I want to sort of start the conversation with that question, right? With that challenge for all of us to figure out how we move forward in this moment. Moving forward, for me as a young lawyer, again, working night and day on the Bruder and Gratz affirmative action cases. But before that, there was Bakke. And I want to introduce Bakke for those of you who have not already been exposed to that case because it was an early effort from what some would say is an unlikely leader when it comes to thinking about diversity, thinking about people coming together from very different contexts to work together to do something special and unique as part of our roles in this space. The Bakke case is really the first time that we see justices engaging in questions about diversity and what came out of that were really decades of cases where justices from very different backgrounds, not everybody, some justices were not embracing diversity in the way that others did, but many did. And that was a sort of shared effort to move forward. Again, not always sharing what moving forward looked like, but knowing that if we were going to get somewhere, we had to do that sort of shared work. And so the work that I did on the Michigan cases, the law school and the undergrad school were a big part of that effort. Eventually, Justice O'Connor became the leader on the court, and she wrote the main opinion in the law school case. But even in the undergrad case, where there was a loss, the sort of core of diversity and what it offers for those of us in a democracy was really lifted up. Challenged after the Michigan cases, certainly the Fisher cases. Some of you are in my comma cases, so you're probably just dozing off a little bit. Oh, here she goes again. Those cases were very, very important in just helping us think about what we do. Right? How long do we engage in this exercise? There was a point in one of the oral arguments where Justice, I'm a perfectionist. He's going to be very upset with me for that. But Justice O'Connor sort of raised the idea, right? Articulated an idea of diversity and inclusion that spanned all of us, right? She had an idea that the need for this might not be long-lasting, but it was important. And you see across the cases after those cases, and then also in the Fisher cases too. The Fisher cases are interesting because that is when the Fisher cases came after Grutter and Gratz, but again, an opportunity to talk about diversity in that space. I represented with a couple of friends of mine, members of the Texas Assembly, who wanted to have diversity as a sort of clear metric for them as they move forward. And so we represented them on two different occasions. There were some disagreements among the justices about what we should actually be doing in this context. What does it mean to have diversity years after O'Connor's opinion? But still, there was a real focus, and even Justice Kennedy, who wrote the most important opinion, said, hey, experimenting around diversity, figuring out how you deal with problems in communities where people come from different spaces, those things are all on the table. That's all part of what this exercise in diversity and inclusion should be. I could go on. I'm not going to. I'll just say this to sort of push us forward toward our current moment. What Mr. Bloom, who really led the effort to challenge the work that Harvard has been doing around diversity, could not have been farther from where O'Connor and others were in thinking about this, because his idea was we shouldn't be engaging issues of race generally. The way that vehicle he used for that is focusing on individuals who identify as individuals who identify as who come from a background of an Asian background, for lack of a better word. I'm trying to sort of come up with a word that is expansive and including. Hopefully you know what I mean. That is expansive and involves and accepts people from different backgrounds. What he wanted to do in his efforts around Harvard was just to really challenge the way that students were evaluated as candidates. And of course, as hopefully you all had an opportunity to look at it, made some critiques of what they were doing in admissions. Something similar happened in the UNC case as well. What you could take away now, and maybe we'll have room to come back again, is this, that there may be something that drove Bloom and Abigail Fisher, who was one of the litigants in the Fisher cases, to focus on these questions that I sort of set out. But I want to sort of push back on that just a little bit, right? Which is to say that I don't think that their efforts were about real engagement across differences. I think that they had a very clear focus and desire, as I think is likely to happen in the cases that will be heard next month, to really dismantle the hard work of creating and maintaining diversity. And for me, that's a big loss. And I think that's true for others as well. And it also, for me, reveals how little investment those at Bloom in particular had in diversity. And he's made a commitment over years to dismantle the kind of diversity that O'Connor or others might do. I'm not one who normally calls folks out that way, but I think it's important because it goes to a question that I hope will be engaging one another in the time that follows. And that is, what do we do if we're not willing to give up on that experiment of engaging one another, looking, thinking about diversity, right? We have some answers in the earlier pieces that I talked about, but right now, it's just us. It's just us. And how do you move forward in a way that will allow us to maintain those things that are dear to us? Our democracy, our engagement, our communities. How do you do that? I would suggest that Bloom's approach is not going to get us very far. We've got to do something else. I don't think we're likely to see that something else among the majority in the cases that will be heard in October. I gotta get a ticket, so maybe they'll change the tenor of things. But we have, I think, collectively, as lawyers, as soon-to-be lawyers, as teachers, to think about what it is that we can do to move forward. I don't have all the answers. I have some that I'll share with you, but now I'll just stop.
Thank you so much, Robin, for that. And, as you were going over the sort of history, it struck me that the three leaders on this issue were all center-right. Justice Powell, Justice O'Connor, Justice Kennedy, all of whom are, we've come to a point where the center-right has kind of collapsed, right? And we just have right. Or who we call the center-right has shifted quite a bit to the right. And so we're at the point, and I think this is sort of the message you're delivering, where it looks like the direction the court is headed in is in the direction that Bloom has been asking them to go for a while. And the question then would be, if that does come about, where do we go from there? And maybe that's a different conversation.
One I'm happy to have with all of you. We have to work together if this experiment is going to work.
Kelsey on 303.
Yes, although your comment about going to see the argument reminded me, if you don't hear this,
Can people in the back here? So.
Is this better?
Yes.
I just want to make sure if you don't hear this in any of your other classes, the Chief Justice has announced that arguments will be open to the public again after the pandemic. You still having trouble with me talk? Okay. I haven't heard any different protocols from before the pandemic, but there is a public line that you can get into and get seats. The justices have certain seats reserved if you've gotten in. I don't know how early you're going to have to get there. I know for Lawrence v. Texas, the line started 24 hours in advance. But but you all, I'm not going to say you will have time on your hands, but you're young and good at doing things. So get together with a couple of friends, whether it's even closer. Again, I don't know what time you can send someone scouts out to go look and see what time the line starts, but certainly during your time in law school, it's really exciting that the court is open again. You should try to do that. And if you don't have the appetite 24 to 48 hours in advance, maybe try a really boring case. Just get there at maybe 5 or 6 a.m. So, okay.
I would say 5.
At least in the beginning, I think people are going to be so excited to be back in the courtroom. So I'm going to talk about the case 303 v. Elenis. How many of you were at the faculty meeting or the okay, so a lot of you already are experts in this case. So bear with me as I catch everyone up, and maybe since we did the faculty meeting, we come up with some more hypotheticals. So for others in the room, Professor Bornstein and I argued this case for the 1L orientation that we moved a few weeks ago. So the plaintiffs in this case are a woman named Lori Smith from Colorado and her website design company, Creative. And they brought suit to challenge a Colorado public accommodations law, which is similar to laws you see in many other states. It prohibits places of business that sell to the public from discriminating based on protected characteristics, which include disability, race, creed, national origin, and most importantly for this case, sexual orientation. There's also corresponding communications clause that prohibits businesses from advertising that they're going to discriminate based on protected characteristics. So Smith would like to expand her design services to include wedding websites, but only for opposite sex couples. She has a religious objection to same-sex marriage. So she filed a pre-enforcement challenge seeking an injunction prohibiting Colorado from enforcing the law against her on the ground that requiring her to serve same-sex couples and opposite sex couples equally would violate her First Amendment rights to free speech and free religious exercise. So if any of this sounds familiar from past Supreme Court terms, you're probably thinking of the Masterpiece Cake Shop. Does that sound familiar? If you were watching the court a few years ago, that was in 2018. So in that case, Colorado officials had determined that the bakery owner, named Jack Phillips, had violated the Colorado law when he refused to sell a wedding cake to a same-sex couple. So like Smith, Phillips argued that the law violated his free speech and his free exercise rights. And in an opinion by Justice Kennedy, the court ruled very narrowly that Colorado had violated Phillips' religious exercise rights by selectively enforcing the law against him in a way that displayed hostility towards his religious beliefs. And in entering that ruling, the court relied heavily on statements that had been made by state officials at public hearings, which the court held cast doubt on their impartiality and fairness towards Phillips. And that was the extent of the Masterpiece decision. The court did not make any more general ruling about the constitutionality of the Colorado law. So this case is a follow-up effort to get that broader ruling. But the court made an interesting decision when it granted review. Smith's cert petition asked the court to consider both her free speech challenge and her free religious exercise challenge. When the court granted the case, it limited its review to the free speech claim. So the case is now fully briefed on the merits and expected to be scheduled for oral argument in December. So that's another one. If you don't get into the admissions case, you can try again in December, although it'll be colder to be overnight. Go on, your heart. So a few observations based on my reading of the briefs. The first is that the parties agree that the creation of wedding websites, the graphic artistry that Smith does, is creative expression. But they fundamentally disagree about whether the Colorado law is regulating that expression. So the state characterizes the law as a prohibition on discriminatory sales practices that leaves businesses entirely free to choose what products and services they offer. And in particular, the state says, if Smith wants to only offer wedding websites that have biblical quotes on them or that affirmatively state that marriage is between a man and a woman, she is free to do that. She is free to say every single wedding website that I make is going to state that marriage is between a man and a woman. What she can't do is tell someone they can't purchase that site based on a protected characteristic. You might wonder why a same-sex couple would want to purchase that website, and that is a good question. But what the Colorado law is doing isn't regulating the expression, it's regulating the sales of that expression. And so we see that distinction, right? The First Amendment protects the creation of products or creative products, but not the sale. And so, for instance, an author would have a free speech right to put whatever they want in their book. You can write a book about whatever you want. But once you put that book for sale on Amazon, you can't say to Amazon, but only sell this book to people of a particular race or religion. So Smith does not disagree with that distinction in the context of off-the-shelf products. Her argument is that this situation is different because she plans to customize her services for each buyer, and that the customization process is itself creative. And in particular, she says that she is going to offer as part of her services to write a narrative out of each couple's unique love story celebrating their relationship. And so requiring her to write out the story of a same-sex couple would violate her First Amendment rights. She also notes that she will serve gay and lesbian customers who seek her services for products with that express messages that she agrees with. So, for instance, she'd be happy to make a same-sex couple a website advertising an animal rescue shelter. And she said that shows that she's not actually discriminating based on the protected characteristics. She's discriminating based on the message that she's being asked to endorse. The Solicitor General filed a brief in support of Colorado, emphasizing in particular the breadth of the injunction that Smith is seeking. She wants a categorical exemption that will allow her to state on her website that she does not make wedding websites for same-sex couples. So that would include not only the creative process of writing out the couple's love story, but also, for instance, if she offered fill-in-the-blank template websites where all you do is put in the name of the couple and the date and place of the wedding, right? That wouldn't be creative expression, but would fall under the injunction she's seeking. Now, Smith's response to that is, oh, I'm not going to be doing template websites. So that is irrelevant here. But I think that just highlights another issue that's lurking in this case, which is whether the dispute is ready to be decided, whether it's ready for adjudication. So recall that when I described Masterpiece, a same-sex couple had asked Phillips to make them a cake. He had said no. The couple filed a complaint with state officials, and they found Phillips in violation of the law. Here, the state has never sought to enforce the law against Smith. She hasn't even offered wedding websites for sale yet. She's seeking a pre-enforcement injunction based on things she says she wants to do in the future. So a lot of this seems very hypothetical at this point. And there's a possibility when the court starts to dig into the case, it finds that the lack of a record makes it difficult to decide it. So just one more comment. I said at the beginning that the court decided to take this only on the free speech question. And what that means is that while this particular case is about a religious objection to same-sex marriage, the challenge is not limited to that context, right? If you have a free speech right not to make a wedding website for same-sex couples, I would assume that you also have a free speech right not to make a wedding website for interracial couples if you're opposed to interracial marriage. I also have trouble finding any distinction in the briefing that would distinguish this case from one where a white supremacist makes wedding websites or offers photography services. Says, I'm not going to do that for people of color because I don't believe their lives should be celebrated. Right? If you have a free speech right, it would apply in that context also. So I'll be interested to see in argument whether Smith's attorney get any pushback on that issue and in terms of finding some limiting principles in this case.
Thank you. So, not to put you on the spot or anything, but where do you think the court is headed here?
I don't doubt that there are 6 justices who are sympathetic to Smith's position and believe that she should have an exception from the Colorado law. I mean, I just think based on where this court is at right now, I think they're going to have a lot of difficulty reaching that result in this case in a way that doesn't create a host of problems. So I think it could ultimately be a situation where you have 6 justices wanting one particular outcome, and a whole bunch of different, 9 justices with 12 different opinions on how you reach that result, whether you end up getting a majority opinion under those circumstances, whether they end up getting frustrated and doing something along the lines of what they did in Masterpiece and focusing on a narrower ground to rule in her favor, or dismissing the case altogether because it's really difficult to decide these issues in a case without a record. I'm not sure. We'll get a better sense of it.
Thank you. Mike has the independent state legislature theory.
So, everybody else, can you hear me in the back? So everybody else has a really sexy case to talk about. So, Kelsey said this, I might have the most important one. But this is one of those structural, like, con law 1 cases. And it may not be as exciting to listen to. So what's involved in this case? North Carolina got an extra seat in Congress in the 2020 census. And the North Carolina legislature got together to draw a new congressional map. And they did. And that map was challenged as a partisan gerrymander. And the North Carolina Supreme Court said, yes, it is. That is a partisan gerrymander. In our view, that's a violation of the North Carolina Constitution. So we are setting aside that map, we're sending it back to the legislature, draw up another one that isn't partisan. They drew up a second one, and the court said that one's just as partisan as the first one. And now we're getting close to election time. So we are going to adopt a map. In fact, they had some experts who drew up a supposedly nonpartisan map. And that was the map that was going to control the upcoming elections in November. The state legislature asked the Supreme Court to review that decision. And they did so contending that that decision violates Article 1, Section 4 of the Constitution. So what does Article 1, Section 4 say? It says that Congress could, if it wanted to, make the rules that govern the time, place, and manner of the election of senators and representatives to the United States Congress. But that if Congress doesn't do so, the time, place, and manner of holding such election shall be prescribed in each state by the legislature thereof. Now, the original draft of the Constitution said it would be determined by the state. But somehow, before the Constitution was adopted, that language was changed to single out the state legislature as the body that would develop the time, place, and manner of election. And the argument that's being made by the state legislature in this case is that the Supreme Court of North Carolina has no right to undo the map that we created, that the Constitution of the United States gives the power to us, not to the state courts, not even when they say, oh, but the map you drew violates the state constitution. So it's important to know that in this case, unlike in some states, the North Carolina Constitution doesn't have any specific language that forbids partisan gerrymandering. There are states that do. All that is in the North Carolina Constitution, and this is what the state Supreme Court drew up, it says election shall be free, and it has an equal protection clause. And the court wove those two together and say that the correct interpretation of our Constitution is that those two clauses mean that you cannot have a partisan gerrymandered set of districts for Congress. And the question is, how is the court going to respond? This is the so-called independent state legislature theory. Now, what I've given you is the broadest version of it, and it is the one that appears in the state legislature's brief, that there is no room for the state Supreme Court with respect to this. There is a middle ground, which is, well, if the state constitution has clear enough language that says that partisan, that gerrymanders you can't have partisan gerrymanders, that districts have to be, contingent, fit properly and coherent, et cetera, that maybe then that would be okay, because then the state Supreme Court would simply be implementing a decision that was made at a policy level in the Constitution of the state. But that when the state is fabricating, this is the word Justice Alito has used, fabricating a constitutional limit out of words that don't address the drawing up of congressional districts at all, that is too much to satisfy a constitutional provision that says that the time, place, and manner of elections will be determined by the state legislature. So what is the background of this in terms of history? The court has had a couple of cases not involving a state Supreme Court overruling the legislature, but early on that a case in which a governor of a state vetoed the map the legislature had drawn. The legislature said, oh, that violates Article 1, Section 4. The Supreme Court said, no, when the Constitution says it'll be done by the legislature, that means by the legislature subject to the usual constraints under which the legislature operates. In that state, the governor has a right to veto legislation. That's part of the legislative process. They had another case, these are long, long time ago, another case from Ohio. Ohio, at that time at least, had a rule that anything that the state legislature adopts could be overturned by a vote of the people in a referendum. And the state legislature had adopted a map for congressional redistricting, and there was a referendum, and the public overruled that map. And the Supreme Court said that's okay too, because the state's process for legislation includes the possibility that it could be overridden. But the question in this case is, does this give the court the right to overrule legislation? And the argument is the court is different, particularly different when it's not drawing on specific language in the state constitution, but simply, finding something that probably wasn't intended at the time in the Constitution. That this is in effect the state court substituting its policy judgment for that of the state legislature. And that offends the provision in the US Constitution that says it's the state legislature that will make these decisions. So we have a couple of things for guidance on this. As you probably know, 3 years ago, the Supreme Court held that we, the federal Supreme Court, are not going to get into the business of judging partisan gerrymandering. We don't think there's language in the US Constitution that is specific enough to enable us to find that any state map is a violation of the federal Constitution. But in that opinion, which was written by Chief Justice Roberts, the Rucho case, he said this doesn't mean that there's nothing that could prevent partisan gerrymandering. He said the states, for example, some states are actively addressing the issue on a number of fronts. In 2015, the Supreme Court of Florida struck down that state's congressional district plan as a violation of the Fair Districts Amendment to the Florida court. So that constitution had a provision specifically talking about the fairness of districts. And they said that there would also be no problem in a constitution that said that no districting plan shall be drawn with the intent to favor or disfavor a political party. Those are instances where the state constitution speaks directly to this. And the theory is, in cases like that, the state legislature isn't making policy, the state court is not making policy, it's simply implementing the language of the Constitution. Now, in this case, the state legislature filed a cert petition and they asked for a stay. They said, we want to run our upcoming election under the legislature's map, not under the map that was adopted by the state constitution, by the state Supreme Court. And the US Supreme Court denied their motion for a stay, but there were 3 dissenters, Justices Alito on behalf of himself and Justice Gorsuch and Thomas, said, I think the state deserves to win this case. That in the absence of clear language and clear direction in the state constitution, that in effect, the state Supreme Court is operating as a policymaker. And it's made even more complicated in this case that the state Supreme Court actually drew up the map that's going to be used. Now, he only had 3 votes. Does that mean that the other 6 are prepared to uphold what the North Carolina court did? Not necessarily, because Justice Kavanaugh wrote a concurring opinion, and he said, I am not going to grant a stay, but the reason is because the election is so close in time that we can't disrupt things at this late date. He didn't express a view one way or the other on what the outcome should be. He said both sides have good arguments. it may be that all 6 of them who denied the stay only because of the timing. And so the question is the court going to do something which is really quite unusual for the court to say, this state Supreme Court is purporting to apply its own constitution. But we're going to say that the federal constitution doesn't allow them to do that unless they have clearer language. I think there's some realistic chance that that the 3 who did this dissent would not get 2 more votes for that. It's up in the air, I think. But there's a second question. Even if we say that the North Carolina Supreme Court is entitled to strike down any map that is a political gerrymander, does that give them the right to draw up their own map? And here we have a little bit of guidance from a dissenting opinion that Chief Justice Roberts wrote a few years ago, in which he said, look, it's fine to have, the legislature and then have trappings like a veto and stuff like that. But you can't cut the legislature out entirely from a constitution that says that the thing will be drawn by the state legislature. And so it's a conceivable possibility. The court would say, well, it was okay for the state Supreme Court to strike down the particular maps that the legislature drew, but it wasn't okay for them to draw their own map, because now they really are engaging in a policy decision, which is committed to the state legislature. So I think any possibility here is I think it's hard to predict what the court's going to do about this. We know where 3 justices are. They're going to say what North Carolina did is not allowed. I think we can fairly predict that the 3 liberals on the court are going to come out the other way. They've come out the other way in every gerrymander case, probably will do so here as well. But the other 3 on the conservative wing of the court, it's hard to guess, I think, where they're going to.
So Mike, one question I have is, just sort of evaluating the political context in which the court has to make this decision. Will it have any impact on how the court thinks about it? So I think the political context is that at least some state legislatures have gotten more and more restrictive in their voting rules. And on the other hand, a fair number of state courts have, particularly during the pandemic, interpreted their state constitutions to liberalize voting rules. And do you think that that is the relevant context in which the court will see this? Or alternatively, could they just say, well, sometimes the state courts interpreting their constitutions could be more restrictive, and sometimes the state legislatures adopting rules could be more generous, and so it really isn't the right way to think about this question?
Well, I do think that the implications of this case go beyond just political gerrymandering, because they would apply to anything that involves the time, place, and manner. So, and we know that after the last election, there were entreaties to a number of state legislatures to overturn the vote for president by saying in some fashion or another that there were errors in that. And incidentally, the Constitution also says that in selecting electors, they shall be selected by the state Senate. So this issue comes up there as well. I think it would be more tolerable even to people like Alito and the others who are in the dissent here. If a state would say it's a violation of equal protection to adopt some, procedural rule about how you're going to vote that is clearly going to have a disadvantage for some groups, identifiable groups to vote as compared to others. But I think the court is going to have in mind that when it decides this issue, that it is writing in a context in which virtually everything that has to do with the time, place, and manner of elections is potentially going to be affected by what they write. Now, which way that cuts, I don't know. I think gerrymandering is in some ways unique. The court has struggled with gerrymandering for years, and finally, as far as the U.S. Supreme Court is concerned, they threw in the towel and said, we are not going to do this. And it's clear that at least Justice Roberts and maybe more of the people in the conservative group recognize that there is and should be a role of the state courts to play in monitoring partisan gerrymandering. But they may say that that's only going to be true when the state constitution has language that's specifically directed to it. That's really what's at stake in this.
Thanks, Mike. Warple?
Great. So first, I just want to say it's great to see this wonderful crowd here. For me, the Supreme Court Institute is always a real professional highlight of my year, and so I'm delighted to be here. I especially love watching Professor Gorenstein grill and guide the best lawyers in the country. And what's always amazing too is that he becomes this expert, right? You already see it in every area of the law. So here's my chance to make you an expert in copyright. Here's Copyright 101. What is a copyright? It is an exclusive monopoly right that goes to authors for their lifetime plus 70 years. So if you're lucky, it's a right that goes to authors for a really long time in their original expression or creative work. That's fixed, like it's got to be in a form like a book or a film or an MP3, it's fixed. But basically, the purpose of the law is to incentivize creativity, creative works, and expression. It's the engine of free expression, it's been called by the Supreme Court. What do you get when you get a copyright? Well, there's really a bundle of rights that you get, but the two key ones for our purposes is you get to first control copies. So that includes exact copies and substantially similar copies. But the second big right that you get is you get to control what are called derivative works. And derivative works are really broad. Basically, the Copyright Act defines them as things like translations, musical arrangements, the motion picture version, but it's really like anything, the video game version. There's a catch-all phrase in the statute that says that derivative works are basically any other form in which an original work may be recast, transformed, or adapted. So that's like a huge set of rights, right? That a creator or an author may get under the Copyright Act. So really long duration for a copyright, really broad rights for a copyright, but the 1976 Act also put in to the statute a really important defense, and that is the fair use defense. That's section 107 of the Copyright Act, which specifically says that it may not actually be, even if it seems like a defendant's use is violating one of these core rights of a copyright owner, it may not actually be an infringement if the defendant is using the work for things like, in the statute, in the preamble says, purposes like criticism, copyright, criticism, comment, news reporting, teaching, scholarship, or research. These are examples of the kinds of works that you might be able to use, but it says in order to determine whether or not it is a fair use, that you have to go through a 4-factor analysis. So there's 4 factors in the statute. What are the 4 factors? The 4 factors are: 1, what is the purpose and character of the use that the defendant is making? So is it a criticism? Is it like, we're going to be looking at what kind of use defendants making with the original work? What's the nature of the copyrighted work to begin with? Is the original work highly creative? Is it Harry Potter? Or is it something that's more like, factual or a law review? I won't say that that's not creative and expressive. But is it something that's more like largely fact-based, right? And so the things that are more fact-based are going to get less protection. Things that are highly creative, like Harry Potter, are going to get more protection. So it depends on what kind of work the underlying work is. Then the third factor is looking at how much, the amount that's taken by the defendant from the original work. So the amount and substantiality. So it's a quantitative as well as qualitative issue there. The fourth factor is what's the effect upon the market for the original. So is the defendant really a direct competitor now? Are they presenting a substitute for the original? Those are the kinds of questions that the courts are going to be looking at with these different factors. So what happened, and now I'm ready for the slides. Oh, is it working or no?
It is not working at the moment. These pens are bent. And I just got dealt with that hand,
I'm sorry about that.
but I'm working on it.
Okay.
I got you.
Okay, sure. So let me just tell you what happened, and maybe we'll be able to see some pictures so you get a better sense as well. But basically, go back to the 1980s. I was a teenager, and Prince was all the rage. So it's 1984. I still remember when doves cry. Okay, I just couldn't get it out of my mind. 1984, Vanity Fair wants to do a big cover story on Prince. And they basically get a one-time license from a photographer, Lynn Goldsmith. She's actually pretty popular for photographing celebrities. And so she takes a photograph of Prince in the early 1980s. Vanity Fair gets a one-time use license for her photograph, and they say it's for an artist's reference. She doesn't know who the artist is. The artist turns out to be Andy Warhol. So Warhol creates a Warhol out of Ms. Goldsmith's photograph, and that is, basically highlighted in the story. In fact, it's even in the headline. It's like they talk about Prince, but they also say an artist, rendering by Warhol. So it was a big deal. And she didn't really pay attention back then. Prince died, right? In 2016, everybody was doing retrospectives and stories about him. But what Ms. Goldsmith didn't know is that Andy Warhol not only created the one artist reference that was licensed for Vanity Fair in 1984, but he had actually taken her photograph and done 15 prints. He called it the Prince series. And that series was now very, very valuable. Prints from that series were now very, very valuable after Prince died in 2016. So she saw this, that her photograph had been used in these pieces. And so the question is, because Warhol never had a license for the Prince series, right? And so what does it mean to get a license? Well, first, if somebody owns a copyright, and here there's no question, Ms. Goldsmith owns a copyright in her photograph, and in fact, photographs are highly protected. They're extremely, important expressive works, okay? So she owns a copyright, but, and so normally that means that in order to do anything with her work, you have to get her permission and, come up with a royalty that you both agree with, right? So Warhol did neither, didn't ask permission, and didn't, pay anything. So the question really before the Supreme Court, or there are two parts to the question. One is, was it a fair use what Warhol did? And fair use basically means you don't have to ask permission and you don't have to pay anything, right? But even more specifically, the question is, what is the right test for fair use? So that's really what's going before the Supreme Court. So what's the relevant precedent? So the most relevant precedent about fair use that is relevant to this case is the case of Campbell v. Acuff Rose. It's a 1994 case, so it's almost 2 decades ago now. There was a more recent fair use case just a couple years ago, Google v. Oracle, but it dealt with software and not really on point with respect to the issues here. So we have to go back to 1994, and this case dealt with a rap group, Two Live Crew. And so the rap group Two Live Crew, they reached out to Roy Orbison, who's famous for many things, but especially Pretty Woman, the song Pretty Woman, which is the song, you might know it from the movie with Julia Roberts, or maybe no one's even seen that. It's kind of old, I don't know. So anyway, Two Live Crew reached out to Roy Orbison because they wanted to do their own version of his song Pretty Woman, and Roy Orbison said, no. I don't know who you guys are. This doesn't sound right to me. So they said no. Two Live Crew went ahead and did it anyway. And it's very familiar in terms of their version. I don't have time to play it all for you, but you can go, Google it. But basically their version has the same melody, but they change up the lyrics a lot. They're much raunchier, okay? Bawdier. Like, I think the Supreme Court called it bawdy, not raunchy. So the Supreme Court dealt with whether or not this was fair use, because again, they didn't get a license, right? And so the Supreme Court famously articulated, basically they said, all 4 of these factors that I mentioned to you guys are important, but they said that the first one's very important. The first one about the purpose of defendant's use, the purpose and character of the use, it's really important, and especially we want to look at the issue of, is defendant's use what we call transformative. So does defendant, quote, and by transformative, the Supreme Court laid out the language saying, does defendants use, quote, add something new with a further purpose or different character, altering the first with new expression, meaning, or message? So is the defendant creating a different work with a different purpose or a different meaning or message? And if so, that's going to be really important. Even though there are multiple factors to be considered and weighed, this is a pretty important factor. So the court ultimately said that Tulev Cruz use was fair use. It was highly transformative. In fact, it was one of the most transformative uses you could put a work to because it was a parody. It was making fun of or criticizing Roy Orbison's original work, the Supreme Court said, and so that was considered fair use. Fast forward, really for 20 years, this idea of whether defendant's use is transformative has kind of become the golden ticket to getting to fair use, right? So, and in fact, empirical studies have shown that once a court decides that a defendant's use is transformative, like putting it to a new purpose or meaning or message, they win. Like that's pretty much your ticket to winning. So there was, and I'm sorry I don't have my slides because I was going to show you all these pretty pictures. So basically now, more recently, there was, of course, circuit courts have had a number of important fair use cases, but one of the more recent important ones too was in the Second Circuit, the case called Cariou v. Prince. And this dealt with, I don't know how many of you are familiar with one of the most celebrated appropriation artists of our time now is Richard Prince. And Richard Prince makes millions of dollars from his art, and he basically takes other people's Instagram posts or photos as raw material and creates something new. And, you know, the photographer's book maybe, you know, is not all that lucrative for the photographer, but when Richard Prince gets his hands on the work, his work sells for millions of dollars. So Richard Prince took some photos of a, you know, relatively obscure photographer, Mr. Cariou, who had spent a lot of time in Jamaica photographing Rastafarians. And so he published a book. It was probably critically acclaimed, but not very profitable, his book. So Mr. Prince, though, just took the pictures straight out of the book and created kind of like collages. Again, I don't have my images, unfortunately, to show you. You can look this up. But basically, he really contorts the images, distorts them, and makes them really kind of scary and provocative for sure. And so the Second Circuit said, you know what, this is transformative use. He didn't get a license from the photographer, but it's transformative use because, well, we don't really know what Richard Prince is doing. But basically, the Second Circuit says he's created a new meaning, right? New meaning and a new message here. Where, ironically, the artist himself says, "I don't have any meaning to my work." That's like, you know, degrading to even ask me like what my work means. So there's kind of a debate there. But basically, this case was quite controversial because by this time people are thinking, is this transformative use test doing any work anymore? And in particular, the key thing that hangs in the balance is, remember I told you, artists are supposed to have a derivative work right, the right to transform their work into other media, right? And so the question is, what's left of the derivative work right? And that's where this new case comes in, because this case went before the Second Circuit, and the Second Circuit was feeling that this new message or meaning test was really too broad, and they kind of pulled back. And they said, instead, the court said that we should be forbidden. Courts should be forbidden from trying to ascertain the intent behind or meaning of works at issue. And so the Second Circuit offered a different test, and they said, basically, a work is not transformative, and this is where the pictures would really be helpful. They say it's not transformative if the new work quote, recognizably derives from and retains essential elements of its source material. So if the new work, if Warhol's version looks too much like, is too recognizable and looks too much like Goldsmith's photograph, then it's not transformative. So then now we're at the Supreme Court, right? So what is the question before the Supreme Court? The question before the Supreme
Got some pictures.
Oh, good, yes. Okay, so this is Ms. Goldsmith's original photograph, right? And that was the licensed Warhol artist rendering in 1984. But then he went off and did these are 3 of 15 other prints in the print series. So here, the Second Circuit saying that this question of whether or not there's new meaning or message in Warhol's work, they're saying we should be forbidden from asking that question. Who are we, judges and lawyers, to answer that question? We should just be looking at whether or not the defendant's work, whether the plaintiff's work is still too recognizable, right? Can you recognize the plaintiff's work? And I think here, well, if that's your test, we know who wins, right? So that's the issue before the Supreme Court. It's a battle of 2 tests. The long-standing, for almost 20 years, test of, it's fair use. Well, it's not necessarily fair use because you still have to go through all the other factors, but you have a strong chance of winning if, transformative use means you just show that the defendant has brought a new purpose or meaning or message to the work. What the Second Circuit's offering is a lot narrower. So I'll just sum up by saying kind of what's at stake here, right? So one issue is has the evolution of and the growth of the transformative use test, has that made the derivative work right meaningless? And that's a really important question. And so that's going to be something that I think the court's going to focus on, as I think it should. But then at the same time, the future of appropriation art hangs in the balance as well. So this is the right of an artist to take things that are already cooked in one context, but to act like they're raw material in a new context. Do we want people like a photographer who maybe only would make a few $100s from licensing an artist reference? Ms. Goldsmith did not make a lot. It was several $100s or something to license her photograph for an artist reference, even for Warhol to use. Do we want that person with that right to be able to hold up art that's priceless? Or, okay, at least worth millions, okay. But so I think that there's a couple ways the court could go about this, right? But one is, in the patent context, there was an important case, eBay versus Merck Exchange, where the court said, you know what, we shouldn't always presume that the only remedy for a patent holder or patent infringement is an injunction. Because in the copyright context, that's what we have right now. If Ms. Goldsmith or Mr. Carreyrou can have the threat of an injunction looming over these artists, then they can really hold up great art, right? So one question is, might the court go the way of the eBay v. Merck Exchange direction, which is to say maybe we should have damages here, right? So because remember, the purpose of copyright, promote expression, right? The engine of free expression. So just as much as we need to be thinking about the copyright owner's incentives and to create, and here you don't just have an incentive to create to control direct copies, but that derivative work right is a huge part of your incentive, right? So these are a couple of the things that hang in the balance. I think it's going to be. I'll just say 2 last things. I think it's going to be hard for Warhol too, the Warhol Foundation, because they're not using they're not using the photograph to critique or parody or comment, which we did have in the 2 Live Crew case. And then finally, I think the court. So I think the court. I am worried though that I don't want the court to narrow transformative use too much to say it's only transformative if it's critique or parody, right? I think we still want to have some good flexibility there. And I think the last thing the court should weigh in on though is how important is this transformative use issue with respect to the other factors? It is a 4-factor test, but we've kind of come to act as if it's just a 1-factor test. And so I think those are some of the things. Last thing I'll say is my copyright students are coming to the Moot. But before that, next week, we're all going to the National Gallery of Art to see the Double Identity exhibit to get a better appreciation for what's actually the subject of our study here, art and humanity. So I just have one
question, which was, you said Prince actually said his thing had no meaning.
Yeah.
And yet, somehow he won under the new meaning of message
Yeah.
test. Maybe it went from having meaning to having no meaning, and that's but the other thing that I wondered about this one, and I can't remember if you said this or not, you may have. This went supposedly from shy Prince up at the top here to iconic Prince down at the bottom here. And is this really something that a standard that makes sense to have, I don't know who, go in front of juries and tell jurors that the one up on the top there is shy Prince and the one on the bottom is iconic Prince. So I just, that's the one, yet you told me at the same time that this has pretty much been what's been going on for the last 20 years. And so maybe it's more workable than I think it is.
But I think you're right that one of the problems is lawyers and judges don't really feel comfortable saying this is a new meaning or this isn't a new meaning. And that's why the new meaning test is probably just sounds like new meaning to me. I don't want to judge. And we have a lot of, precedent in copyright law with Justice Holmes himself, introducing something that we now understand as the non-discrimination principle. We don't think lawyers and judges can make these judgments well. And so we're pretty much non-discriminatory. It's all new art. It all must have some meaning or no meaning, but let more flowers bloom. So I think that's kind of maybe one of the things that's led us in that direction of thinking the new meaning, means it's transformative. The other thing I'll say to that though is that's also like this disconnect between lawyers saying, well, obviously it has new meaning, and artists saying, don't talk about meaning, right? So I think that there's I think a really interesting artist brief that's been submitted to the court, which kind of gives us a sense of the way artists approach these questions, and I think that it's important for lawyers who work in this space to understand the art that we're helping to regulate and affecting how it's created and all of that. So I think those perspectives matter. They don't necessarily translate well to the language of the law. So
all right, let's have some student questions. Anybody? Yes, go for it, but be loud. Stand up and be loud.
Question for Professor Corcoran about 303, but also a little bit more broadly about, if you could speak to kind of the rationale why the court might decide to pick up a case or why they might not. I mean, it seems like this case is pretty structurally unsound, and if they can only hear so many cases per term, why would they decide to pick one up that they don't even know they can decide on?
Yeah, that's a great question. So one interesting feature of the Supreme Court is that while it takes 5 justices, to reach a majority on a merits question, it only takes 4 justices to grant cert in a case. And I think people speculate that the justices are sometimes strategic about that, the idea that there's a defensive deny, right? If you don't think that the position you like is going to get 5 votes, you'll vote to deny the petition because you prefer that over a ruling in the wrong direction. But I think sometimes you see, I don't want to just start dropping case names at you, but over the last couple of years, cases like 303 Creative, where there was some blockbuster question, and then ultimately the court decides it in a really narrow way. Masterpiece is an example of that. There's Fulton, the foster care, same-sex couples in foster care question. And so, only the 9 justices are in the conference room. So this is, we're just guessing, but I imagine that what happens sometimes is there are 4 justices who are just really enthusiastic and interested in reaching an issue, and so they grant the case, and then once they start to really dig into it on the merits, they realize it's more, the posture is more complicated than they thought. Now, in other cases, that happens, and they seem to just kind of go right over the complications. So, for instance, there was a case a couple of years ago, the New York gun case, where ultimately the issue appeared to be moot because the gun regulation that was being challenged was no longer in effect. did not stop the court from reaching it. And you'll probably see right now, there's some talk about the Kennedy case from last term with the praying football coach. And there was a lot of, there's a lot of criticism of the majority opinion, perhaps taking liberties with the facts of what actually happened in this case. And it turns out most recently that the football coach has been offered his job back and hasn't taken it, which also shed some doubt on what was actually before the court last term. So I think, we don't know at this point which direction this case is going to go in. Are they going to kind of just smooth over the wrinkles and reach the question that they want to reach, or are they going to ultimately have to do something more narrow? And that's just going to be about counting, right? Are there five who want to do one or the other?
More questions?
Yeah, thank you all very much. Should the court go with the independent state legislature theory, would that have any impact on the role of the governor or on independent commissions?
I think not. That is, I think the rationale in the Alito dissent is that the problem here is that there isn't enough guidance in the state constitution to say that what the state Supreme Court did is really a judicial role rather than a policy-making role. Now, with respect to the veto, you could say that's a policy decision too. The governor doesn't like it, but that is well-founded in the law. That's everything the legislature does is subject to that. Now, you can say everything the legislature does is also subject to the state Supreme Court saying what you did is unconstitutional. And that obviously is the argument that's being made in defense of the state Supreme Court is, of course, they have to construe the state constitution. They wrote a very thoughtful opinion about why they thought these little words, elections must be free, equals, you can't have a partisan gerrymander. That's what Supreme Courts do. And so there's nothing really unique about this. It shouldn't depend on how precise the constitutional provision.
Another question? Yes.
What are the practical consequences if the court overturns Brother?
If it overturns.
Yeah. Like it has the broadest.
If it bans the use, this is Rudder you're talking about?
Yes.
Yeah.
Yeah. If, it's a good question. I think if Rudder goes away entirely, right? That's what you're contemplating. Yeah, I think Rudder is I think if Rudder goes away, then we lose a good amount, but not all of what could be done. Right? I think that you still with Rudder, there would still be some room to utilize some of the ideas that are animating Bakke, for example. I'd say that. I don't want to say it wouldn't be there in whole, but I do think that there still might be a little bit left.
Other questions? Yes.
This is for the Harvard case as well. How would the court go about addressing the petitioner's argument that race is not a proxy for a person's experiences or views? How would they go about addressing that?
How would the court say it once more? I think I lost it.
How would the court go about addressing the petitioner's assertion that racial stereotype that race is a legitimate proxy for a person's experiences? How would they address if that view is valid or not? Because they argue that Rudder's rationale is based on that, and that's incorrect.
I think it's a good question. I mean, I think for the court, I mean, I don't know that they might be able to look at the materials that they have some sense of the direction in which they might go, but I'm hesitating because what might be there. And I sort of peaked myself in the sense that I don't think there's a lot there. That I could see the justices saying, we need to know more about that. So, yeah, I think it's a hard question, but I don't think what is being offered now is enough yet. At least I don't think it should be enough. That's more accurate.
Question? Let's go over here. Yeah.
Okay, in Moore versus Harper, to what extent are presidential electors at issue as opposed to just the issue of gerrymandering? Could the court rule on just gerrymandering without also validating control of appointment of presidential electors in the same manner?
Right, well, that's a good question. So there is a risk, obviously, if they say that unless you have a clear state constitutional provision that's being violated, that you can't overturn this. Now, the selection of electors is a little bit different, and I'm not sure everybody remembers this. You don't have to have elections for president. The original Constitution, what the Constitution says is electors shall be selected in the manner that is chosen by the Senate, and at the time, the state Senate. And at the time, it was expected that most state senates would select the electors without having an election. Now, over time, we now have elections in every state. And presumably, there are going to be some standards in the state constitution that could be invoked to say that something was violated. But I do think that, though obviously this opinion is not going to address that squarely, that the choice of words that they use to describe what a state Supreme Court can and can't do could have similar implications if the state Senate overturns the vote of the people on some ground, and the state Supreme Court wants to say, you couldn't do that. That's not consistent with what our view of the state constitution is. So I think, the core argument that's being made by the defenders of the North Carolina court is, as long as the state Supreme Court says we are applying our state constitution, it's none of your business, Supreme Court, U.S. Supreme Court, how specific or unspecific the language in the state constitution is. The state Supreme Court is the one that tells us what the state constitution means. And unless you're prepared to say that the state Supreme Court couldn't overturn the state legislature no matter what, I mean, that is the core argument on independent state legislature. You can't overturn them no matter how plainly they're violating the state constitution. That is not going to get 5 votes in the Supreme Court. Is this clear that everybody joined Roberts' opinion, which said that at least with this clear language, they can do it. But if they're not going to adhere to the view that anything the state decides as to the meaning of this constitution is fine, if they're going to say it's going to depend on the clarity of the state constitution, that would have implications. If a challenge is made to a state senate that overturns the will of the people.
One more question. Go this way.
Professor Sumner, what happens to parity if the court chooses to go with a narrow standard?
I don't think parity's going anywhere. That's a really strong, solid law. I think it's more about, will they just limit it to parity, or comment and criticism, including parity. I don't think they should go that far in narrowing. I think there's a lot of ways they can get around this. So they could just say, even if it's transformative, here, the fact that it's so similar, like that. The other factor is the amount and substantiality used, right? And so that would actually take care of the recognizability test without adopting a new test called recognizability test, right? Because that's just coming out of nowhere. So I think that there's a few different ways they could go about it without really unsettling long-standing approaches to fair use.
Okay, thank you, everyone. Let's have ice cream.